Traffic news. It is Thursday, April 23rd at 1:48 PM, to be very exact. We are picking up S-179. We took some background testimony earlier in the week on just trust in general. This is another bill on an act relating to Uniform Disclaimer of Property Interests Act. I have a note from Chris Root, who will not be joining us because Senate is sort of moving all of their money bills in the course of a few hours. And so Chris is downstairs, but there is no anticipated fiscal impact to the revenues of the state from this bill. Eric, can you tell us about the word impact to the state of this?
Yes, I can. Good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here, as the chair said, to talk a little bit about with the committee about S-179, which is an act relating to the Uniform Disclaimer of Property Interest Act. I'm just, I think, a moment away from sharing my screen. That visible behind me now?
Yes.
Oh, yeah, thanks. All righty, so there's S-179, the language of the bill as it's come to you from the House Judiciary Committee. For a moment or two of background, there's a lot of lengthy legalese in this bill, as there frequently is with uniform acts. This is one of them. So what is a disclaimer? It's a formal refusal to accept the transfer of property. That's what a disclaimer is. Somebody may be trying to transfer you or somebody property, whether it could be in a will, might be a beneficiary under a will. You could be a beneficiary in a retirement account, 401k account, something like that. You could be named as somebody in their will might name you as the executor or the healthcare power of attorney. And you don't want to do that either. This Uniform Act actually does permit you to disclaim those kinds of things too, these fiduciary appointments. But it's interest, any kind of interest in property that for whatever reason, it could be because there's tax reasons for it. It could be because you just don't want it. It could be someone's trying to transfer you their, falling down camp in the middle of nowhere that has really got a lot of debt attached to it. You're like, you find out in the will 10 years later, hey, that's actually going to you. Maybe you didn't want that. So this is a legal method by which you can disclaim those interests in property. So what do we have now? Well, there is one on the books right now. This isn't the first Uniform Disclaimer of Property Interest Act that Vermont would pass. The one that we have was passed in 1986. So 40-year anniversary of this year, coincidentally. And it was drafted by the Uniform Law Commission in 78. So it was drafted in 78. Passed in, Uniform Acts get passed, not every state passes it every year. So, and not all states pass them, all of them necessarily, but this particular one, originally drafted in 78, first draft passed in Vermont in 86. And then you have this revised version, which was drafted by the Uniform Commission in 2011. So 15 years ago or so now. And now, if I understand it correctly, the Vermont Bar Association had a committee of the trust and probate sections looking at the revised bill, and they were looking at it to see if it would be advisable to pass it in Vermont. They thought that it was, and hence they recommended its passage. And that's the language that you have in front of you that passed the Senate and House Judiciary and is now in front of you folks. So that's kind of the narrative story of how it got here. So question might ask again before we look at the language, well, what's the difference? What's wrong with the old one? Or at least what changes
are made? Keep on changing everything.
Exactly. I know from the drafting perspective, I agree. But I think, the policy decisions are for you folks, obviously, but some of the just sort of examples of changes that are made, or at least things that are addressed that weren't addressed in the previous bill. For example, the Uniform Act that you have on the books now, that Vermont has on the books now. The one that you're looking at in front of you clarifies the timing. In other words, when do you have to make the disclaimer for it to be legally effective? How soon after the interest is created, do you have to make your formal disclaimer for it to matter? As it happens, the existing statute on the books has a requirement that has to be made within 9 months of the interest being created, which seems sort of random. And the reason for that, though, and I'm going to let your witnesses be able to talk about this in a lot more detail than I will be able to, and more expertise as well, that the original Uniform Act was based, or at least it was passed in the wake of a federal tax law that was passed in 1976. And that law specifically said for disclaimers that if you want to disclaim and get a tax gain from it, a particular tax gain, it had to be done within 9 months. For whatever reason, then this entire Uniform Disclaimer Act, or at least the one Vermont passed, also mimicked that 9-month requirement that you have to disclaim within 9 months for it to be effective. But you think about it, that's much broader than the feds were just saying, if you want to gain this tax benefit, you have to do it within 9 months. Not that you can't ever disclaim for any other reason, but you might not have a tax. That might not be the reason you're doing it. You might just be doing it because you don't want the camp, something like that. So this gets rid of that 9-month time period. And it would still apply under federal law if you still want to, because that's a federal. That's if you wanted to gain that tax benefit.
So what is happening during that stretch of time when you're not disclaiming?
You might not even know about it. Like you might not find out until the will gets allowed by the court. And then you get a call from the executor that says, hey, guess what? You got this house or you got this camp. Or happens to be an example that I know of from personal experience. You might not have known that someone who this hypothetical person's family, who decided that they wanted you to be the executor of their will. And you don't find out about it until later on. And person never told you. So you could find out that way, hypothetically. What's that?
That's the first.
No? Right. So what if you're like, hey,
I never signed up for this.
never signed up for it. Hey, and doesn't that person want their own kids to do that? Hypothetically, right.
Hypothetically.
Right.
So could you sort of have custody of this thing for 2 years and then disclaim it?
That's a very interesting question. And the answer to that is in the language that, yeah.
Okay, let's talk through the language.
Well, I'll give you, because good answer to that just is, if you exercise the power, like if you have it and you exercise it, then you can't disclaim it anymore. Like you can't just do it and, hey, well, maybe I'll do it for a little while and then I'll disclaim it. No.
Okay.
So that was sort of trying to have it both ways, and you can't do that.
Thank you.
Yeah.
When you were saying disclaim the tax benefit, were you saying disclaim the taxable benefit?
No, I just mean that, and I don't have expertise with the underlying tax law, but I think the concept is that by disclaiming, you then do not own the property for purposes of whatever tax liability might attach to it. And so, and the federal tax law had said, okay, you can do that, but you have to do it within 9 months after the property goes to you. And if you wait till after the 9 months, then you can't disclaim anymore. So it's not, it's in a sense that you are exercising your authority not to take the property at all.
Because for some individuals, it might create a tax liability.
Exactly.
Yes.
Yeah.
Okay.
And federal law would still control that part. The issue, the timing. The issue under the Vermont law was that there's plenty of disclaimers that might have nothing to do with whether or not you're trying to get, not pay a tax liability because you owned it. There are other reasons that you're disclaiming it. And for whatever reason, I wasn't here in 1986, but the Vermont provision had that 9-month requirement for any kind of disclaimer, all of them. Not just, even if the reason you were doing it had nothing to do with tax law, tax consequences. So that's another one of the changes that's in the revised, updated uniform law. Another one happens to involve parents can disclaim on behalf of children as long as there's no conflict of interest. We'll see that, but that's another piece that wasn't addressed specifically in the original one that's on the books now. There could be partial disclaimers, like maybe you might want part of an interest, but not another part. That's also permitted specifically. Entities can disclaim. For example, this university or that museum doesn't really want that gift that somebody's providing in their will. Maybe it doesn't, for whatever reason. And so this provides an entity, makes clear that an entity can disclaim as well. So those are, I think, some of the main sort of substantive kind of specific pieces that the new updated Uniform Act has that weren't addressed in the old one.
Could you say you would accept the land, but not the painting on it, or the land without?
I think you can partially disclaim. Yep. Yep, you could. I should have thought of that.
Would that do property tax purposes? And property tax classification purposes that would consider.
Whoa.
That's beyond my level of expertise, but that's the same question. Yeah.
Too far into the land of hypothetical. I love it.
Well, we
I
can
think-
think about it as we
Because-
go forward.
Yeah. I think there's a question is, I think the question, maybe the first step in the question you're asking is what would the new ownership structure look like?
I think even, and I'm going to defer to one of your witnesses on this, but it reminded me of something I looked at. I think that disclaimer is clearly under the act, not a transfer. So that being the case, the property transfer tax, real estate property transfer tax wouldn't apply because it's clearly defined as not a transfer. So that may solve part of that problem.
I forgot the property tax, yes.
Eric, do you want to take us through the bill?
Yep. So those are the big picture differences between the revised act and the one on the books. And I'm going to go fairly quickly because it's pretty lengthy. But if I am going too quickly, you have a question, want to pause, please jump in. Thanks. Short title we just talked about, the Uniform Disclaimer Property Interest Act. Definitions section in the beginning, pretty straightforward. Disclaimant is the person who disclaims. The interest is what you disclaim. The disclaimer is the actual refusal to accept. Fiduciary, a term this committee are very familiar with, I'm sure. Trustee, personal representative, et cetera. Jointly held property. Actually, I forgot to mention that. That's another thing that the revised act addresses specifically that isn't as clear in the existing act, which is that jointly held property, one of the joint owners, because remember, people can own property jointly. I think I've even spoken to this committee about that earlier this session in a different context. But so that allows one of the joint owners can disclaim their interest as well. All right, so trust also, that's another, I think I didn't actually mention this, another thing that's addressed in this bill is that third parties can disclaim, for example, a fiduciary, a trustee, someone like that, someone who holds a power of appointment, that person can also disclaim. For example, a trustee could disclaim, and if they do, then the property wouldn't go into the trust. So, some general language about scope and the supplementing other laws. So the general power to disclaim, the first one you see is in section 4105 of the bill. And this says basically that this line 12 and 13, that's your general statement about what's going on in this entire bill. A person may disclaim in whole or in part any interest in or power over property, including a power of appointment. So any interest you have in property, including a power of appointment, can be disclaimed. And really, the rest of the bill, if you think about it, is really just the procedures of solving that big concept. And details about how you disclaim, and that will often depend on what's the type of property interest being disclaimed. That has obviously an impact on how it is you do it. A fiduciary may disclaim, that's subsection B, which I mentioned. Fiduciary can also disclaim. So in other words, it could be a trustee, it could be a personal representative, could be an executor of an estate. Those folks can all disclaim. I mentioned this before. You see line 5, page 4. A parent can disclaim. That's line 5 if there's no conflict of interest. All right, how do you disclaim? Subsection B, a couple of requirements. Has to be in writing. Generally speaking, requires a writing. And then there's some details about that. It has to be signed. So you have a written disclaimer generally required. Subsection E, page 5, I mentioned this as well. A partial disclaimer may be expressed. So partial disclaimers are, or you can, like you were saying, you can take the camp, but not the land it's sitting on potentially.
Yeah, Representative.
So D says to be effective, it has to be in writing,
Yeah.
et cetera. You don't say dated or witnessed, even though like for real estate, maybe. But, you have to have it witnessed and so you have to add those things in there.
I think there is some language on that. Yeah, hey, oh, sorry, I should be looking at this stuff, this one instead of the, where was I? Oh, there we are. So page 4, line sort of starting line 18 down there, signed means by the person, it in the presence witnesses, et cetera. Yeah, absolutely. Yeah, it is sort of tucked away in there. So yeah, those are the formal writing requirements of it. Timing, when does it become irrevocable? Subsection F, that's when it's delivered or filed. Oh, here's what we were mentioning too about the fact that it's not a transfer, specifically set out subsection G. Disclaimer is not a transfer. So not subject to the transfer tax. And then we talk about, the next sections you'll see really just are specific procedures involving the types of interest that's being disclaimed. You're talking about property and how that's going to work. What rules apply? Well, that goes on the next page. It takes effect as of the time the interest that creates the interest becomes irrevocable. Talks about how it gets passed to another person if the person doesn't take it. Generally speaking, if like it could be like you think, for example, if you're a document that creates a power of attorney, oftentimes they'll say, well, there's a secondary power of attorney, right? If the first person doesn't take it, there's another, you can designate another person who would have it if that person doesn't take it. So this is just basically saying if you have that in your document, then that's the way it works. If you've designated some alternate, alternate, I think that's the word that's usually used. That person would take it. Yeah.
Is there a way to prevent somebody from disclaiming to, when, let's say you're doing your will,
Right.
and you have an executor and you're gone, and how can you prevent that executor from disclaiming any, is there a way to prevent your executor from not fulfilling their duties once they accepted it? Or anything else?
They're bound by this fiduciary capacity. They have this legal obligation to act on behalf of the interest of, in the example you described, the person who passed away, right? The person who drafted the will. So, sort of the enforcement mechanism there is the probate court. You could say, look, this person is not following the instructions that were provided for by the decedent, by the person who passed away. They're in the will. So I think there's at least one general enforcement mechanism to kind of force that person to go along with the directions. But you might have to ask that question of some other witnesses as well, with more experience in the practice.
Yeah, it can be costly.
True.
Being an executive.
Yeah.
In the state,
And time consuming.
absolutely.
Yeah.
Anyway,
What's that?
they do a very good will, it's not. There's a way to get out of it. I know people who are not now.
You mean who don't want to be executive anymore?
Yeah.
Yes, you can do that as well. Yeah.
What else do we have here?
Can't be forced into servitude.
Also, just.
Let's continue on through the.
Right. All right. So again, as I say, there's different. So this is providing for procedures for the type of thing you're disclaiming. This one happens to involve jointly held property. Remember I mentioned that one person property is owned jointly. One of the owners can disclaim. That happens to be involving rights of survivorship specifically. That means that, let's say if a person passes away, then the property goes to you. You can disclaim. You don't want it to go to you. Trustee can disclaim. See that 4108. Power of appointment can be disclaimed, or any other power that's not held in the fiduciary capacity. Also provisions for that. Anybody who's appointed, if the power of appointment, there's the timing works differently depending on whether the person who has this power of appointment has exercised it yet. So if you've done something, let's say you had a power of appointment for healthcare, say you made some healthcare decision on behalf of the person, well, then it's more limited at your ability to disclaim it if you haven't actually exercised the power yet. any fiduciary capacity disclaimer, there's procedures for that specifically. Then you get to 4112, well, that's the method we were talking about. Okay, those are all the types of property that can be disclaimed. How do you do it? And you remember it mentioned earlier on when we looked at the language that generally it's effective upon delivery or filing. So this describes how that delivery or filing is done. So you see subsection B there. Generally speaking, delivery may be effected by personal delivery, first-class mail, any other method. So that's how you can deliver to somebody that, hey, I'm disclaiming, put it in the mail, in writing. I'm not taking it. One way. For specific provisions for how to disclaim under a will or under a trust, that's subsection D. Different types of trust, actually, D and E, how to disclaim in that circumstance. I was just mentioning if you're the beneficiary under a will or some other document, there's one procedure for it if you're designating before it becomes irrevocable and another afterward. If it's real property, interesting subsection H, if you're disclaiming an interest in real property, you have to record it. Generally speaking, anything related to real property has to be recorded in the land records, like the deed, that sort of thing. These are fiduciaries, holders of jointly held property, et cetera, methods and procedures around that specific type of property ownership and how they go about disclaiming. Trust or an estate, someone with a fiduciary over one of those property interests, again, delivered, as we just said. So these are all the specific methodologies for how that's done. Now, under certain circumstances, you can't disclaim. And this is something that the chair had been referring to earlier, which is, well, what if you've already done it? Well, then you're not supposed, if you already exercised the power that you're given, then that puts some limitations on your ability to disclaim. But generally speaking, you see how you do it, subsection A, you can do a written waiver of your right to disclaim. So in that case, you couldn't disclaim if there's a written waiver, your ability to do it. Now, this is interesting. See subsection B1. Let's say it's an interest in property. If any one of the following events occur before the disclaimer becomes effective, subdivision 1, you accept some of the interest. So you can't accept it and then say, well, no, I changed my mind. Right. So if you accept it, you accept it. Or if you give it to somebody else, that subdivision 2, then you can't disclaim anymore. If the court sells it, you can't do it then, obviously. Section 4114 provides basically that if as a result of this disclaimer, the Internal Revenue Code treats the disclaimer as meaning that the property was never transferred. In other words, it's an effective disclaimer from the IRS's perspective. Then it's effective as a disclaimer under this chapter as well. So they view it that way. State law does as well. Permitting recording, as I referred to with real property. And you have some boilerplate that is actually in virtually all Uniform Acts, relation to electronic signatures, application to existing relationships, uniformity of application. This sentence occurs in all Uniform Acts that can, when these types of acts are interpreted, that have to give consideration to the need to promote uniformity in law. Section 2, you'll see line 15. That's an important one because, as I mentioned, Vermont law currently does have a uniform disclaimer, Property Interest Act. So this repeals that one as well. So this would take the place of the existing Uniform Act that you have. I think that's it.
Yeah, thank you.
Yeah.
This seems to be, it's a little tongue in cheek, but I'm serious. You seem to have included everything. Is there anything left out? I mean, you seem to have pretty much covered all bases.
Well, I can know it was a Uniform Act, so the original language was provided to us by members of the Bar Association who had worked with the Uniform Act language. So hopefully they caught everything. They have more expertise in this area.
That is, what's the word I'm looking for? But anyway, that is gratifying, but I mean, it's
Reassuring?
Reassuring, yes, thank you very much. Mr. Attorney, sir.
Thank you, Eric.
Yeah, sure.
I think that is pretty much the only thing. So it's like, well, takes away the old one, puts in a new one in its place.
Exactly.
It's been done.
Exactly. Modernizes it, really.
Yeah, no, it's very thorough. I commend, I guess, it's you and the Bar Association for their thoroughness. And I would gather that the Bar Association has been sorting out things like this for several years now and put them all in one place and say, let's do it.
And Representative Maslin, we're about to hear from the Bar Association.
Oh, that would be wonderful. Save my questions.
Yes, Representative Brennigan.
Well, thank you. Appreciate it. Oh,
No money involved on this thing, no revenues to this.
yeah, not that I'm aware of.
Chris Roop notified me he's not able to make it into this room, though he can if people really want him to. He'll run upstairs, that there is no revenue. There's no impact on the revenues of the state.
Cool. Thank you.
You
Eric.
bet, you bet. Thank you. Should I leave this on the screen? Do you want me to? No, pull it down? All
Carry
right.
on with your. Computer.
Right.
Thanks,
You bet. Thank you.
Thank you.
Mr. Langen. Hi.
Hi.
Thank you for joining us here on Ways and Means.
Well, thank you for having me.
Absolutely.
Yeah, I was here a week ago last Tuesday.
Oh, yes, I'm sorry, I was not at that time. I heard that everyone really appreciated the big picture lesson thing. Seriously, I had a bunch of people tell me like, that was some of the best testimony we've taken.
Oh,
Yeah.
great. I actually attended a seminar in Boston, and one of the speakers talked about how trust got started in English common law. And the way that it did, this is sort of interesting, is that the clerics couldn't own property in England. So the way they got around it was the creation of trusts. And, I had told you that trusts are an English invention. So it started in the 13th century or 12th century, and it had to do with a way for people who were in the clergy to hold property through somebody else. So I'll introduce myself, at least for the record. I'm Mark Langen. I am the chair of the probate and trust law section of the Bar Association. I've been the chair for about 11 years now. And I brought many uniform acts to the legislature for passage. And one of my colleagues, Matt Getty of Rutland, said we should pass the uniform, the new uniform disclaimer act. The one that we have on the books is not workable. And so that's why we initiated a committee. The committee had about 9 members, and we scrubbed through the, this disclaimer act was drafted in around 2010, 2011. So it has been around for a while. It has been adopted by 25 jurisdictions, including New Hampshire, Delaware, Florida. So those are kind of important jurisdictions that we have interactions with as practitioners in Vermont. I think Eric did a good job with the walkthrough. So I just want to give you more of the 30,000 foot level of why you should pass this statute. Because just a little history, what happened is in 1976, Congress passed the Tax Reform Act. And what they did was unify the estate and gift tax sections. So we only had one exemption and one rate. It didn't matter whether you transferred your property as a gift or as an inheritance. It was all going to be in one big system. And at the same time, they passed section 2518 of the code that says that, dealing with disclaimers, they said, listen, if you don't want your transfer to be a taxable gift, you have to do 4 things. You have to disclaim within 9 months. You got to put it in writing. You can't take an interest in it before you disclaim, and you got to deliver it to somebody or file it. One of those 4 things. And if you don't do that, you've made a gift. Okay. So then 2 years later, the Uniform Commission gets together and they said, we need a uniform act, to do this. Well, what they did was and we ended up passing it, it's a 78 Act, we passed it in 86, but it flipped it and it said, you cannot disclaim unless you've done so within 9 months in writing, not taking an interest in it. You cannot disclaim. And basically, under the common law, you could disclaim at any time. And that was kind of a crazy idea because you're just saying you can't disclaim. Well, what if I want to disclaim? So what? It's a gift. I might have to file a gift tax return, you know? So, and in today's environment, where the federal exclusion is $15 million per person, you don't care if you're making a gift. And the thing is that the 9-month deadline that we're under is very pernicious. It's secretive because it's when the interest is created. When the interest is created. So, and two things we have going on in our practice here in Vermont that I see a lot. We have a bulletin board sort of on the Vermont Bar Association, and people are bringing up things. And I can see there's two things kind of going in the realm of disclaimers. And one is called the enhanced life estate deed. Many people are doing these. They're basically giving their property to their kids, and they retain a life estate. When they die, their property avoids probate, goes right to the kids. And the reason that a lot of times they do this for Medicaid planning, because the house still retains its character as if, let's say, mom owns it still. So it would be a non-countable asset. Doesn't change when you do that, okay? Well, when she does the deed, you don't need to get the signatures of the kids. They might not know. They might not know that you did this. And the 9 months clicks along and the kids don't know. They don't know that they're getting the property, and they might say, and then 20 years goes by and mom dies and they say, oh God, I'm getting this property. Maybe I don't want it. And maybe if I don't get it, it'll go to my kids. I got enough. It'll go to my kids. But no, under our current act, you can't do that. So you can't disclaim. So the biggest thing is that we're getting rid of the 9 months. Okay. So just getting rid. And it's more like you can disclaim when you find out that you got a piece of property, that something's coming to you. This happens a lot of times in trust. Husband and wife make trusts, and the husband dies first, and he's made a trust for the benefit of the wife. And then upon the wife's death, it goes to the kids. Kids might not know, and so they might want to disclaim. And there was there were several cases that were, that sort of even showed how more pernicious this was. And it dealt with the Cargill family of Minnesota. So, the wealthiest, largest family-owned company. So, and they were in different courts and they were fighting over the disclaimers. Well, it turned out if mom had what we call a general power of appointment as to who she gave it to, and she could, and for tax purposes, it could be her estate, her creditors, or the creditors of her estate, but any of the kids, then the 9 months started clicking when mom died because she had a general power of appointment. But if it was a special power of appointment where you couldn't appoint it to your estate and your creditors of your estate, but you could decide which one of your kids get it, no, the 9 months started clicking away when dad died. And it made no sense because what's the difference? I was thinking, why did the court hold this way? Because you don't know when you're going to get, in either case, whether it's general or special, you don't know when you're going to get the property, if you're going to get the property. And yet we had two different rules. It was crazy. So that's the main reason is let's get rid of this 9-month rule. And then the tax consequences will be what they are. There's a section in the act that says, hey, if you want to do a tax disclaimer, you still got to follow the rules at the IRS level. So let me give you an example of that. Let's say that someone gets beyond the 9 months rule, okay, and we've taken the 9-month rule off and we allow them to disclaim. If they disclaim, it could be a taxable gift. And under our estate tax, your taxable gifts are brought back into your estate for estate tax purposes if they're made within 2 years of death. So we haven't, what's going on in the tax world is not being affected by this act at all. So the second area is that the reason why Matt wanted to change it was, he said, under the current act, I don't know who to deliver this to. So there's a big section on, it's one of the longer sections, and it gives a lot more clarity on to whom it goes to. Eric mentioned just briefly what we've done in joint tenancy, and this also, I wanted to make sure this happens with tenants by the entirety, where spouses own it, because we have a wonderful statute. The current statute is pretty good. It says, hey, surviving spouse, you're gonna get your let's say the husband dies first. You're gonna get you're not.
The husband always dies first.
Yeah, exactly. Best examples. Males die usually earlier than women, and that sort of thing. So basically, for estate tax purposes, the surviving spouse can say, I don't want the interest. Well, the interest might be a half interest if they took the property together. But if the husband, let's say, paid for everything and then later put on the wife as the tenant by the entirety, she could say, I don't want it all. I get 100% disclaimer. Okay, and that can be, and Eric Sock, you can do partial disclaimers. Even though I can disclaim 100%, I'm going to disclaim 25%, 50%, 75%. So it gives you a lot more flexibility.
And then where does it go?
Well, the good question. It goes as if you had predeceased. So we can, and that's the thing about disclaimers. You can't say, I'm going to disclaim and give it to this person. No, I can't do that. Disclaiming says, it's like, I'm not going to take it. So we then have to look for the instrument or what the law is as to where it would go. Okay. So, and usually you have to follow through, but a lot of trusts, they're going to go down the bloodline. So that's why we use it. So it's a really good way for estate planning. And then our current act did allow for fiduciaries, but I did have a case where I was practicing in New Hampshire. And there were two people on the seacoast. They died within 2 weeks of each other. A husband and wife died within 2 weeks of it.
Died first.
I think the husband died first, so, of course. But it caused that they weren't good. They wanted to shift. If they disclaimed, it would go back into a trust and they would be able to reduce their federal tax. But the IRS said to the attorney for the taxpayer, said, we're not so sure the executor can disclaim. And we need you to go get an opinion from the court, the Supreme Court. And by the way, we're not going to participate. And so it was a little bit unusual because in order to get into court, you have to have a case or controversy. You got to have someone you're fighting against on the other side. And the service was saying, no, we're not going to do it. But the court took the case. And then out of the blue, the court called me up and said, we want you to file an amicus brief. So I wasn't even involved in the case. So I wrote the brief, and I did look far and wide. And even though I couldn't find any statutes that allowed executors to disclaim, it was commonly done. I found cases that it was done. So it's been kind of in the common law, but now we have a statute for it. So there's no question that we have to, my weeks of work doing that.
Thank you. Anything else you want to share with us?
No, I don't think I think I pretty much covered the whole act. I think that the section members, and I think we're the largest section of the Bar Association, would be very happy
Oh, good.
if we get this passed.
Okay, well, thank you so much for
Okay.
your time earlier in the week and today. I really
Okay.
appreciate it.
You're welcome. Thanks.
Does anyone need any other testimony on this bill?
That's the same question I asked Eric, but since your outfit is basically the originator of this bill, I'd say, good, congratulations for your thorough work, sir.
Okay, thank you.
In your organization, your
Yeah.
organization, whatever.
Yeah. So to address your question earlier about, this covers the world of property. So property usually comes in two flavors, real estate
Yeah.
and everything else personal. And personal comes in two flavors, tangible stuff you can touch, stuff you can't touch. And it's all affected by this act.
Awesome. Good, thank you very much.
Okay,
Thank you so much.
okay, you're welcome.
Is it comfortable for folks if Representative Burkhart calls the roll from the computer? Okay, she's not going to vote. She's just going to call the roll.
That would be fine.
Okay, great. She just doesn't want to use up one of her voting days. You only have 3.
I do.
And we have months left to go.
I hope not.
It's a joke. It was a joke, guys.
It's on me.
Okay. Okay, everyone. Here we have S-179 before us.
Madam Chair, I would move that we find S-179 favorable.
Thank you so much, Representative Kimball. Any, Representative Kimball has moved that we find S-179 favorable. Any discussion? We don't need seconds, Representative Odie. Nope. Okay. Indeed, Representative Odie. Any discussion? Seeing no discussion, if the clerk could please call the roll.
Absolutely. Representative Brannigan,
Yes.
I will not vote as I am off-site today. Representative Higley,
Yes.
Representative Holcomb,
Yes.
Representative Kimball,
Yes.
Representative Maslin.
Yep.
Representative Odie,
Yes.
Representative Page,
Yes.
Representative Wazazak,
Yes.
Representative Canfield,
Yes.
and Representative Kornheiser.
Yes.
We have voted the bill favorable 10-0-1.
Thank you, everyone. Representative Odie, can you report this, please? Thanks. There's no revenue impact to the state. There's your sentence. Okay. Folks, we are next going to move to S-327. We'll take a 2-minute break while